Hi, my name is Babak Shamsi. I'm one of the attorneys here at Beresford Booth. Thank you for taking the time to join me for today's webinar. Today's webinar is going to be regarding the enforcement and termination of easements. This is actually an addendum to the previous webinar I did some time ago regarding the establishment of easements. So if you haven't seen that video, it might be worth checking that out after you reviewed this webinar, as they are related content and would be useful to understand how easements are established, in addition to understanding how they are enforced and how they can be ultimately terminated. I will, however, do a brief primer in this about how easements are established and what easements are before moving on to the enforcement and termination of them. It won't be as in detail as the last webinar, but it can be helpful in case you're just checking into this and haven't seen that one. So I'll just get started here. Easements are a non-possessory right to use or enjoy someone else's land. In other words, an easement grants the holder a limited privilege to perform certain acts on another person's land without owning that land. It is a right to use but not outright own the land owned by another person. The party who owns or enjoys the use is referred to as the benefited party or the grantee. They are the one who owns the dominant estate, whereas the party who owns the property that's subject to the easement is the burdened party, and that makes sense. Their property is burdened by the easement, or they are the grantor. They grant the easement over their own property to the grantee, and they own the servient estate. And there are two major types of easements. One is an appurtenant easement, and one is an easement in gross. An easement in gross is an easement not tied or dependent upon the occupancy or ownership of a particular parcel of real property. So this is interesting. It comes up often in the case of utility lines, public roads, railroad rights of way. This is the sort of easement you might get from Seattle City Light or Comcast. These are not the easements we typically think of when we're dealing with easements over neighboring properties and easements between neighbors, and they're not going to be the focus of easements today. In Washington State, easements are strongly presumed to be appurtenant and not in gross. So this is sort of the non-presumed form of easement and not what comes up most often, but they are still in play, and you'll see them from time to time because, well, utility companies and the such need to have access to people's properties in order to provide the services that they're going to provide. An appurtenant easement is easement that is tied to or dependent on the ownership or occupancy of a unit or a parcel of real property. And Washington State, again, presumes easements to be appurtenant easements. They are often recorded. They often, but not always, last in perpetuity, as they say. Essentially, they just last on and run with the land through successive ownerships of that property. And the grantor and grantee can transfer their rights in that fashion to grantees in a conveyance to their own property. And there are a lot of different types of appurtenant easements. We're talking about easements for ingress and egress, exclusive use easements over a portion of a person's property to use it, for example, as a yard or a garden. It really can be any number of different types of appurtenant easements, easements for use of a driveway, and the such. So there are types of breaches of easements that are really important, but before I get to that, I want to talk about not just the common types of easements or appurtenant easements, but how those easements are established. And how those easements are established are generally in four different ways. So one is an express grant. That is what we most commonly think of when we think of easements. That is the recorded document that's been recorded with the county that outlines what the easement is, the legal description of the property, and what the easement is for. Now, the older easements, often from the 70s, 80s, and before, tend to be pretty vague about what can be done under the easement, and that can create a lot of litigation. And so newer easements, especially when we're drafting easements, ought to spell out the terms in a fashion so the parties know what they're getting themselves into, subject to certain considerations. And those easements tend to be a little bit easier to interpret and therefore to properly enforce, and that can lead to fewer disputes down the road because the parties know what they're getting themselves into. Essentially, in a funny way, although people think that an express easement is the best because, and it's the best because at least you have something that has been established in terms of property rights, they can be an absolute minefield of litigation in circumstances where they've been poorly put together. Second form of establishing an easement, and the rest of these are not written and recorded, is an easement by prescription. This is long-standing, continuous, and hostile use of a piece of property in a fashion as if it were an easement that belonged to you. So it's kind of like adverse possession, such as if my fence were 5 feet into my neighbor's property and I treated it as my fence and the boundary fence, and I maintained my side of that fence the whole time for 10 years plus, and I did it continuously and exclusively and all that, I could claim potentially adverse possession to that 5 feet on my side of the fence. Similarly, an easement by prescription, it doesn't have the same exclusivity requirement, but it does require a hostile use, meaning use that's hostile to the landowner, not necessarily that I dislike the landowner, but that my use is hostile to their ownership. 10 years plus of use, and it has to be continuous, and it has to be open. Typically, a prescriptive easement is often found in uses of, for example, a road, a long-standing pathway that can be easily identified, that kind of thing. So prescriptive easements are fairly common. We do litigate that issue quite a bit, but less common, of course, than express easements. And then you've got easements by estoppel, which prevents a property owner from denying access to land where their conduct or representation led the other party to believe that they had a right to it. And in order to show this, you need to meet 3 elements: an admission, a statement, or act inconsistent with the claim afterward asserted, action by the other party on the faith of that statement or act or admission, and then an injury that resulted if the first party contradicts that admission, state, or act. The party invoking estoppel has the burden of proof. Courts strongly disfavor this form of easement. This is perhaps the least common form of easement that I see in my practice. When dealing with these issues, I see prescriptive easements more often, and I see express easements far more often. And then there's the 4th type, which is the easement by implication. And I see this more often than easements by estoppel, but less so than easements by prescription. The easement by implication is where there's no written easement or no written instrument, but where the elements of prescription are not met as well, but there can be one by implication where it's implied from the facts and circumstances surrounding the conveyance of property. So implication, there's 2 different types. There's an easement by prior use. Landowner has to convey a portion of their land and then retain the adjacent parcel. There has to be usage prior to the conveyance that would have required an easement if they were separate properties. And the usage has to be reasonably necessary to the property that would have benefited, and it must be apparent. Reasonably necessary is not the same as strict necessity. Strict necessity would be that there's absolutely no other option whatsoever except for this easement. Instead, it's that there has to be no way to, at a reasonable cost, create a substitute to the implied easement. i.e., it's just too expensive, right? You've got this easement to use a road. You could put in a different road elsewhere on your property that would give you the same access, but it's going to cost you $250,000 to do it, and your house is only worth $350,000. Well, it's very likely, not confirmed, you never know, but it's very likely that a lot of judges would look at that and say, well, it's reasonably necessary to be able to use the current road as an easement, even though it's not an easement. Again, I'm going through really high level, not getting into any specific facts. It's just to illustrate the concept. And then there's something called an easement by necessity, which seems somewhat redundant since I was just talking about reasonable necessity, but it's a little bit different from prior use. There doesn't have to be a prior use. The easement by necessity arises when the 2 parcels are severed. Again, it requires the landowner convey a part of their land, but retain a portion of their land, which essentially creates adjacent parcels that are next to each other. And after the severance of the parcels, it's necessary to pass over one of them to reach a public street or road or something like this. So again, the test is similar, the reasonable cost test. And, in this case, it often requires it being accessed to some sort of route. Essentially, it comes up mostly where if you don't have the easement, you're going to be landlocked and you have no way out. So that is essentially the test, if you will, for purposes of establishing an easement by necessity. So moving on from there, I kind of want to talk about the types of breaches of easements. So an easement breach will really depend on what type of easement it is. Is it an easement for ingress and egress? Is it an easement, through a driveway? Is it an easement for parking? Is it an easement to use a portion of property that is my side of a fence, but for example, is over the record property line, but the other party won't use it, and there's a garden there that I like to maintain, and so they're giving me an easement to maintain the garden, and perhaps that's an exclusive use, so only I can use it. There are a lot of different types of easements out there, and essentially the types of breaches that arise will depend on the type of easement you're talking about. So, for example, if I have an easement over a driveway and a responsibility to maintain it, if I allow cracks in the road, that could be a breach of the easement. If there's an ingress and egress easement and I allow tree branches to block off the ingress and egress, and I have the responsibility under the easement to keep it clear, that could be a breach of the easement because I'm, again, failing to maintain the easement. So there are multiple ways that an easement can be breached through a failure to maintain. That's fairly common. Perhaps even more common is the exceeding the scope of the easement. So again, if you have an ingress and egress easement, it is often, though not 100%, understood that parking is not allowed. Now that starts to get into the nitty-gritty of cases and whether parking was a reasonable assumption of the parties and all of that. But nonetheless, in a strict ingress and egress easement, for example, if one where it expressly says that parking is not allowed, a party parking there might be exceeding the scope of the easement, right? And that is a circumstance we see from time to time. We also see the building of unauthorized structures. So again, going back to the example where I have an easement over my neighbor's property to have a garden. Well, what if I build a shed there? Well, that could, depending on the wording of the easement, be in violation of that easement for me to build that shed there. So while I can maintain my garden there and I'm the only one who can use that property because it's an exclusive use, building a shed is not allowed. And so one important caveat to exclusive use easements, because there are non-exclusive use, which means that the grantor and the grantee can both use the easement area. And then there's an exclusive use where only the grantee can exclusively use the easement area, essentially building an authorized structure on there if the easement is only to maintain a garden would exceed that scope. And so an exclusive use is not the same as an unrestricted use. You can still restrict the use of an exclusive use easement so that the other party who has the benefit of the use, even if it's only for them to use, can't just do whatever they want with it. And this makes sense because even though they get to use the property in an easement, the property owner that's granted the easement still owns it. And there may be reasons, and a number of them, why they wouldn't want the easement holder to do other activities with the easement area that would simply not be consistent with the use of the easement. Again, a third way that an easement can be breached is if you interfere with the use of an easement. This is where the property owner effectively takes action that interferes with the fundamental use of the easement. So the easement's been granted, there's a reason to be using it, and then the owner essentially gets in the way. Classic example is fencing off an essential part of the easement area. Basically, for example, there's an easement for ingress and egress through the yard, let's say, and then the owner decides to just fence it off. And so now the easement holders can't actually walk through the ingress egress area. That's a pretty classic example that happens from time to time. But perhaps the most common example that I can think of with interfering with the use of an easement is putting up a gate in ingress and egress areas. And putting up a gate is an interesting sort of microcosm for the whole thing because it really depends on what is going on in the facts and circumstances on the ground as to whether putting up a gate, again, this is typically found in ingress and egress cases, is putting up a gate unreasonably interfering with the easement holder's use of the property. So, for example, there's a road and the road goes from the neighbor's property through my property. Let's say I'm granting the easement. They go through their property, through my property to get to the public road. And they need to go through there to get to the public road. And I put a gate there. And the question becomes essentially a balancing of the interests. Who's more burdened by the fact that the gate is there? And a bunch of different things can come into consideration. For example, if I don't put the gate there, is there a risk that there's going to be a massive increase in traffic through my property? This can come up when there's a lot of public use nearby where people will just bypass other roads to just drive through my property because it's more convenient if I don't have a gate there. Or, for example, do I have livestock? And if I don't put a gate there, they're going to run free and get away. And I've got some big risk there that they're going to just leave the property and cause damage, or I'm going to lose them and I'm going to lose value. Maybe a gate is reasonable in that circumstance. By the same token, if there aren't those considerations or other considerations, then the courts will go through, they will often just go through a detailed look at balancing those interests. If there aren't those, then maybe I don't have a reasonable basis to put in a gate. And then the other thing is, what kind of gate? Is this a big, heavy metal gate where the other party, if they want to get out of their car every single time to open it, drive through, park, shut it, drive through, and keep going, and they have to do this every single day? Well, court might find that that's fairly burdensome. Or is it an electronic gate with a clicker? Well, that might be a lot less of a burden. But in that case, what do you do about Amazon deliveries? Or what do you do about if people like to order out and have that delivered all the time? Or things like that, where how are those people going to get in? Do they get buzzed in? Is there some sort of a universal code that they can give? And then what are the parameters around that? So gates are a really interesting and particular example of whether or not a party who's put a gate on their own property in an easement area is interfering with its use. And that could be its own webinar, frankly. I'll sort of leave it at that. But that's what I mean when I talk about interfering with the use of an easement, is if the property owner interferes with the use of the easement, that can be a basis for breach. And that's not only in exclusive use situations, that's also a non-exclusive use where, for example, the sort of default is that I can do whatever I want with my property in the easement area as long as I don't unreasonably interfere with the easement holder's use of the property for purposes of the easement. That's the non-exclusive use with no sort of restrictions on me as the landowner. Have I unreasonably interfered? And so the practice tip here, which I've kind of put at the bottom there, is to say, when you're drafting an easement, if you want to avoid litigation, you want clarity, which is 9 times out of 10 what the goal is, if not more. Make sure the easement is specific with regard to scope, with regard to use, so that everybody understands what it's for. Then there's the possible remedies for the breach of an easement. One of the most common ones is monetary damage. Are there actual damages from the breach of the easement? So, for example, my neighbor has beautified this area near the fence that I've granted an easement over, and they've put in a bunch of money for landscaping, and it looks gorgeous and all that, and they have an exclusive use. And then one day I just have a bad day and I take a bulldozer and tear all that out. Well, that's very likely a breach of the easement, and if they've spent a bunch of money on it, there could be actual damages. Another example of liquidated damages. This is not that common in easements, but essentially a liquidated damages clause is where it's often used where it's unclear what the actual damages would be, so the parties just agree that, hey, if there's a breach, this is the dollar figure we're assigning to the value of the damage that occurs. And that's a liquidated damages clause. Again, I don't see that as much in easements. I've seen it on a couple of occasions. That's typically found in other types of contracts. But I have seen it, and it's certainly something to think about when actual damages are not available. But again, it's just not something I see that much, just worth mentioning as an aside. And then another monetary damage is the diminution of value to property. So what is the value of my property where I have an easement over what I'm supposed to have an easement over versus where I don't, or where that easement has been breached in a fashion where now my use of the easement is no longer possible, for example. Again, where it's been bulldozed, the area that I was using to beautify and put in lovely garden, that kind of thing, has been bulldozed and it's all gone. Is there a diminution of value to my property as a whole? Or a better example is where my property has an easement to use a road or something like that, and that's been blocked off. What's the value of my property now because of the breach of the easement? So that'll often involve an expert who can ascertain what the value is with and without the use of the easement, and whether or not having that expert and looking at a diminution of value is useful will depend on the specific facts and circumstances. There is injunctive relief. This is very important, as is the next one, specific performance, and they're sort of mirror images of each other, if you will. But injunctive relief is to stop the other party from doing something that they are doing, right? So again, if I start to put in a gate to block off the ingress and egress that my neighbor has through an easement over my property, they can go to court and seek injunctive relief to try and stop me, right? That is a circumstance, and essentially an order, a court order to stop the party from doing something. Typically, it'll start with a temporary restraining order, which will last for a couple of weeks, a short period of time. That will turn, if successful, into a preliminary injunction, The preliminary injunction will last for the time frame of the lawsuit typically, and then there's a permanent injunction when the lawsuit is over if the party seeking an injunction wins. And then there's specific performance, which that's sort of the mirror image where I force someone to do something. So instead of stopping someone from doing something, I force them to do something because they're not abiding by the terms of the easement or some other term that's related therein. And then the last point is indemnification. Indemnification is interesting. Often will come up in circumstances where there is an easement of exclusive use. That's very common because if, for example, I own a piece of property and I've given my neighbor a portion of it for exclusive use, I still own it. And so if they're doing work there and they're using it and I'm not doing anything and someone gets hurt there, I, as the property owner, could be the one that's sued because even though they're using it exclusively, I own the property. And so I could get sued as the property owner if something happens, if there was some negligence there or something like that, I could be in trouble. And so an easement may have an indemnification provision, which says that if I'm sued as a result of my neighbor's use of the easement area, they have to indemnify me and protect me, defend me, pay any judgments. They might have to go get legal counsel and pay for that for me, whatever it is. And there are a lot of different types of indemnifications. That will sort of protect me in the circumstance where I've essentially lost control over the use. Indemnification gets a little more complicated when it's non-exclusive use, but it may still be of value at that time as well. But certainly one of the possible remedies is to enforce an indemnification provision in the event that a party gets sued and needs the indemnification that's been granted in the easement. And now I'm going to talk about termination of easements. This is where essentially you want to terminate an easement. And there are a variety of different ways that easements can be terminated. The first and most common, perhaps, is where the express terms of the easement itself dictate that it will terminate after a date certain. Actually, I shouldn't say this is the most common, but it does come up from time to time. This is where, for example, temporary construction easements where neighbor needs to have an easement over their neighbor's property to have construction people go through there just for purposes of work to be done on the neighbor's own property, just essentially like access. And that's not going to last forever. Those will last 60 days, 90 days, something like that. And then the easement will terminate by its own terms. I've seen easements that will terminate after 10 years or after 15 years, even though they run with the land. So for example, if I have an easement to use my neighbor's road or something like that, or a walkway, but we've all decided that that's only going to be good for 15 years because eventually they want to remove that walkway to do something else. And we all agree the walkway is not essential for me to get anywhere. It's just nice to walk through and my neighbors are nice. We'll just roll with the example. Let's say they say 15 years, but it's an easement and it runs with the land. So if I sell my property to someone, they get to benefit and use that easement as well. Let's say I sell it in 2 years. Well, they can still use it for, let's say, 13 years. But in 15 years, it terminates. That's the expiration date on the easement. So it can be terminated by expiration. It can be terminated by release. If you are seeking to terminate an easement that is an express easement, the best way to do it is by recording a termination of easement where the parties release their rights to the easement and record a document that expressly terminates the easement. This is the most certain way of terminating an easement and can avoid confusion and litigation down the road. So that's a big one. Third one is merger of title. This is where one owner comes to own both properties and title merges. So me and my neighbor each own a property and then someone else comes and buys both. Well, that person now owns both properties and the easement really doesn't serve any purpose because if, for example, let's say I'm the one who bought both those properties and now I own both properties, I don't need an easement with myself to use the area, right? It's sort of a goofy situation. So at that point, the easement terminates, and what's important is that a subsequent conveyance of the dominant estate will not revise the easement. So let's say I own both properties now, and the easement's gone, and then I sell the second property to someone else, and that's the property that would need the easement. The mere fact that I'm selling it to someone else doesn't revive the original grant. There needs to be a new easement. There needs to be some other basis upon which an easement can be established. It doesn't automatically revert. There is a termination of easement by a prescription. This is not to be confused with a prescriptive easement. But this is where the burdened party causes termination of the easement by obstructing an easement with an intent to eliminate it. So this is where the property owner who's not benefiting from the easement essentially blocks the easement for a period of 10 years, which kind of tracks the prescription requirement. It's obviously a hostile use or hostile interference of the easement. It's going to be continuous and likely open. This can terminate the easement by prescription. It does require that the benefited party try to use the easement and that it is blocked. So this isn't that I put a fence in there, I put a fence to block a road that the other party can use for 10 years. And I leave that fence there for 10 years and that's their easement road, but they never use it. That's not necessarily enough for me to terminate the easement by prescription. And this gets into a lot of details, but there is language in the case law that talks about the party benefited by the easement has to try to use it and has to have it be blocked for the prescription to start ticking, if you will. Typical example is blocking an easement for ingress and egress with fences, landscaping, retaining walls, that kind of thing. There's an easement by abandonment. Abandonment is where the benefited party, again, the party holding the easement that's using the easement area, demonstrates a clear intent to abandon use of the easement. It is not mere non-use. A lot of times I'll get calls from people who will talk about an easement being abandoned because the party who's supposed to use it just isn't using it. That's not typically enough. There has to be an affirmative act by the benefited party showing an intention not to use the easement, and there must be clear and convincing evidence of this. It is a high standard. Now, what that evidence looks like can take a myriad of different forms, but it's important to understand that just non-use without something more isn't enough to create abandonment. And then there's frustration of purpose. This is where the original purpose for which the easement was established no longer exists. The easement basically serves no purpose. This can result in automatic termination of the easement by operation of law because there's no reason for the easement to continue to exist. This is something that gets litigated. It often gets litigated when the property boundaries get moved or changed or adjusted and parcels get changed around, things like that, where the easement area effectively doesn't really serve the purpose that it used to because everything's been reconfigured and now the easement is almost nonsensical, for example, or there's just no reason for it to be there. It could be even the case where a new easement has been established and the old one no longer has any use, but no one terminated it. There was no release ever recorded, and it's still there, but there's no reason for it to be there because it's been superseded by something else and nobody uses it, and it doesn't even make sense to use it, right? And that could be another sort of frustration of purpose, if you will. And then there's easements that can be terminated for vagueness. This is where the easement is so vague, it's not enforceable. This isn't that common. I don't see this often, but periodically there will be an easement document that one will look at it and say, I don't know what this is purporting to do. The legal description doesn't make any sense, or what it's saying can and cannot be done doesn't make any sense. It's incomplete. There's some other kind of problem with it where nobody can figure out what the heck it is. And so that can be terminated for vagueness. So I hope that you found this presentation informative. There's a lot of different reasons for litigation over easements. There are a lot of different ways to establish easements. There are a lot of different potential breaches and potential remedies involved with easements, and a lot of ways to terminate easements. This tends to be a fairly complicated area of law. The nuances can really matter. That's why hiring a lawyer to draft an easement if you're entering into one can be really important. There are a lot of easements out there that are just terribly written. I cannot emphasize that enough. To be frank, I have seen more litigation over poorly drafted easements than cases where there's supposed to be an easement and there isn't. So that is a word to the wise that if you're going to enter into an easement, make sure it's well written and well delineated and clear enough so that you can avoid problems down the road for yourself and others. And so if you have questions or just simply want to talk through some of these issues, or if you run into an issue involving easements or covenants or title issues, anything like that, please feel free to contact me. My information is up on the screen currently. I'd be happy to help you. Many of the attorneys at our office would be happy to help you. Please do not hesitate. Once again, I hope you found this informative, and I thank you for your time and tuning in and checking this out. And I hope you have a nice rest of your week. Thank you.